Morning, everyone. It's 11 o'clock. I'm just going to give people the opportunity just to start joining. I can see that as I've started the webinar, people are beginning to join. We've got fantastic numbers today for the webinar, so I want to give everyone the opportunity to be able to join us. Okay, that's great. I can see the numbers there climbing, but we will make a start. So good morning, everyone, and welcome to our April webinar. So traditionally, April and October have been dates when legislation changes. So it's always a good opportunity in April just to take stock, just to see what the changes are, both in employment and also in immigration, and really just see, what things that perhaps you need to change within your own processes, and also maybe when you need to sort of liaise with other areas within the business, for example, payroll. Absolutely brilliant that Chris Harber can join me this morning. Morning, Chris.
Morning, Emma. You okay?
Yeah, good, thank you. Lovely to see you. Chris is our head of immigration, so absolutely fantastic that he can join us and obviously share some of the changes that are happening in the world of immigration law as well. So just a little bit about Boyce Turner for those who don't know us. We are a commercial law firm based in the Thames Valley. Within the employment team, we do not only employment law, HR support, but also we support businesses with business immigration and also some individual immigration as well. And also we have a separate training arm, which I head up, which supports managers, HR and wider employee populations with training and getting involved in their training programs. So if you want any help and support or have any questions, either pop them in the chat or do please reach out after the broadcast, and I'll be emailing everyone with how you can get in touch with us. As always, we are live. So again, do bear with us, but this is an overview. So as I've said, if you do have any specific questions or queries, then as always, please do get in touch with us. So I'm going to start with having a look at some of the April changes. If you want to hear more about perhaps an overview of what might happen in 2022 and maybe sort of wider, then do look back at our YouTube channel for our January update, where we sort of had a bit more of a wider overview. This is just going to focus on the April changes. So let's, without further ado, well, as most of you are probably aware, April is the month when statutory payments increase. And the first of these is statutory sick pay. And as we can see there, that's increased to £99.35 per week. Remember, of those of you who are following SSP rules, that you have those sort of waiting days at the start of any period of sickness, absence. And obviously after that period of waiting days is then obviously when SSP is applicable. Just a reminder that SSP changed from the 6th of April. Again, there's different dates for when different statutory payments kick in, but 6th of April for SSP. Statutory maternity, paternity, adoption, shared parental and bereavement leave, and also their maternity allowance. So the statutory rate of pay for those statutory payments, that increased from the 3rd of April, and that's gone up to £156.66. So what we need to do is obviously just make sure that we've liaised with our payroll, and also particularly for those individuals whose either sick leave or family leave absence, where that's straddled that April date, just making sure that we've obviously got the correct change as to when those new rates will become applicable. Similarly, with our statutory leave and sick payments, we have seen changes again from the 1st of April to the national minimum wage and the national living wage, and we've popped the rates up on there. So again, check with your payroll, and also just make sure on the ages of your staff as well. So when people have birthdays, and maybe that, sort of tips them into the upper age brackets there. So again, just be a little bit aware, when you're looking at your payroll information with your dates of birth of your staff, just making sure that you've got notes there of when people sort of tip into that later age bracket. Why is the national minimum wage important? Well, the government does publish and has published a list where they have named and shamed businesses that are not complying with the national minimum wage. And just to say that last year, the government named and shamed 191 employers who had not complied, and in fact breached national minimum wage laws between 2011 and 2018. And just to say that of those firms caught, they were ordered to repay £2.1 million to around 34,000 workers who had been underpaid. And on top of that, those 191 businesses were fined a combined total of 3.2 million. So it is legislation that does have teeth. Where do employers get it wrong? Well, usually mistakes happen with regards to calculating deductions from wages, particularly around deducting expenses and deducting costs for things like uniforms. Other areas where employers can fall foul is where they're looking at calculating hours, particularly where individuals are paid on an hourly basis, and also where they are paid for overtime. So again, really have a look at how we're paying people, particularly where you've got people who work who have variable hours and variable pay. And another area where employers sort of fall down is where the apprenticeship rate has been inappropriately applied. So again, just some sort of top tips there on things to watch out for when we think about the national minimum and the national living wage. Another rate of pay which increases in April is with regard to dismissals. Now, these new rates apply for dismissals that occur on or after the 6th of April 2022. And as we can see there, that the calculation for a week's pay, so where we're looking at not just the basic award in unfair dismissal compensation, but also where we look at calculating redundancy pay. That week's pay has gone up to £571. And again, as we can see there, that you've obviously got the maximum basic award there has gone up. I mean, goodness me, I look at the rate of the compensatory award and think back to when I first started as a lawyer. I mean, the maximum award there was around about 11,000. So goodness me, we're now at, for a maximum basic award and a maximum compensatory award, we're looking at, over 100, well over £100,000 now, or of course, 52 weeks pay, whichever is the lower amount. But again, some serious sort of, money involved now. So again, just remember when we're looking at dismissals, when we're looking at redundancies, again, really important to really focus on not just the reason for the dismissal, but also the process of the dismissal. Just remembering that in an unfair dismissal, we need to get both of those things right. So again, if we can help and support with dismissals that you may be going through, if it's conduct or performance or redundancies, then again, do get in touch. It wouldn't be a webinar or so it seems without me mentioning something about COVID. So where are we? Well, we've sort of moved into that living with COVID safely. We've obviously seen the end of free lateral flow tests, but of course employers who wish to sort of continue with testing can still look at, self-funding for such testing schemes. But also we see now that employers no longer have to consider COVID as part of their, health and safety risk assessments. Although what I will say is, and again, just a caveat on that, of course, it would fall within that general obligation to ensure that employers take those reasonable steps, those reasonable precautions to protect the health and safety of their staff, their visitors, or those impacted by what they do. So it is part of that. And also there is specific guidance for those individuals who are extremely clinically vulnerable. So even though there is this sort of, living safely with COVID, of course, we must continue to take those steps that are reasonable, but also really focusing on those individuals who do have who are vulnerable to COVID. So just a sort of caveat on that. And we see, guidance there, particularly around the sort of the cleanliness of workplaces, but also on with regards to sort of, good ventilation practices. I think really just on the sort of the wider discussion, I think, it's really time now to sort of look at, what's worked, what hasn't worked over the last 2 years, really think about, communicating with staff about what our plans might be, but also sort of setting out those expectations and just sort of thinking now as businesses, how we can sort of maintain that element of sort of flexibility, but also ensuring that any plans that we do have don't sort of limit how we want the business to run moving forward. So I think, there's an opportunity to really focus on how we want businesses to work, in the longer term, and how we can really focus on the positives, and that it's okay to enjoy work and enjoy coming to work, and really sort of focusing on the benefits, of collaboration and mentoring and working together. And again, thinking that our workplaces are more than just a physical space, and they can offer sort of, those other sort of working benefits, but personal benefits as well. So again, an opportunity there to really re-engage with how we want to move forward with our workplaces, ensuring that we have that clear line of communication and expectation setting. Many of you will be sort of heaving a sigh of relief that we've managed to get through another gender pay gap reporting date. As many of you will know, we had a bit of a moratorium on gender pay gap reporting, but were in full swing for 2022. And many of you will have had to have a lie down in a darkened room after those reports were filed. But I think, what we get from the data is really interesting. And what I did do, and just to sort of share with you, and you're very welcome to go and have a look as well. I was just doing a little bit of, sort of looking around in terms of the statistics on the gender pay gap reporting. And the TUC has done some really interesting research on gender pay gap reporting and what the gender pay gap means in sort of real terms. And what they've said is that the average woman, when compared to the average man, the word average is always interesting, but basically the average woman works for free for at least 2 months of the year when you compare her pay to that of the average man. It's really interesting there. And again, women still make up the majority of those part-time roles, flexible roles, perhaps those lower paid roles in those sectors, care sector, hospitality, retail. And again, many of those sectors have been particularly hit over the last 2 years. So it's quite interesting. So that's a really interesting statistic there. And I think the other part to note is that there is an age disparity as well, and certainly the age gap does increase the older that you get, and also when women become mothers. So again, for those aged 40 to 49, the gender pay gap is around 21.3%. But in our 50 to 59-year-old age bracket, the gender pay gap is 21.8%. And when we think back that actually that demographic in terms of age and female workforce is the biggest demographic in our businesses, that's a really, quite scary prospect. So, there is lots to learn from the gender pay gap reporting. And I think it's not just the actual reporting, but also what we're going to do with the information that we get and how we are looking to close that gap, be it looking at our our pay, looking at those roles, looking at those sectors and how we can improve things, looking at how we can make roles more rewarding, and encouraging more women to progress into those senior roles as they move forward with their careers. We've just had a quick question here about gender pay gap reporting. Certainly it's looking at that 250 employees on the sort of the snapshot date, but certainly what we have seen is a number of clients and actually a number of businesses actually looking at the calculations for their businesses where they're not caught by the actual sort of legal requirement to produce a gender pay gap report. They do that because they might well fall within that 250 employee bracket sooner. So let's get prepared now while, so we know what we're dealing with before we tip over into that next bracket. But many do them because actually it's really interesting. And when we think about recruitment, when we think about being that destination employer, that place where we want people to join us and we want people to stay with us, actually looking at our pay and looking at how we can be more representative and more diverse within our workforces actually is a really interesting thing for employers to do. And again, we are seeing a lot of clients who are doing it, not to publish per se, but actually using it as really useful information about where they sit and how they pay people and what they can do to improve that diversity within their workforces. So again, a really interesting thing to do, even if you're not necessarily caught by the regulations themselves. And just really to sort of flag a couple of our next events with you. So our next webinar at the end of May, we're going to do a case law update. It's been quite busy actually in the tribunal calendar, so it'd be interesting to share with you some of those new cases. But the HR Masterclass is really something that I want to sort of raise and really sort of say, this is a course that we've run. We've had a bit of a hiatus for the last couple of years, but looking to rerun it. It's a 2-day course, which I run. And really it's a course that's designed for HR, written for HR and delivered for HR. So whether you're new to an HR role, if you want a refresher, or you're returning to a career in HR, or you found yourself in a situation where you're looking after the sort of the people management within your business, then it really is the course for you. We look at issues from how HR would deal with it. So, we're looking at where HR is involved in processes, so be it performance management, absence management, or conduct. We look at what contracts of employment are and how we can use our contracts more effectively. We look at obviously diversity and how we can look at the Equality Act and how we can use that and look at some of those key risk areas and key curveballs. So it's a 2-day course. As I said, 9:30 till 2:30 to allow people to flex it with their working day, or to go back into their offices in the afternoon and really kind of, share what they've done. But if you are interested in attending that course, I want to keep it small. It's run like a classroom. But if you want the opportunity to come and meet like-minded professionals, share knowledge, share experiences, takeaways, then do book. I'll be sending out the booking link for that as well, but I really hope to see that. And thank you so much to people who've booked already. I'm really excited to meet you. I'm going to be running it in person, hurrah, from our offices in Reading. So again, a real opportunity to come and get out there and do a face-to-face course. So Chris, it's been a busy time in employment, but it's been an even busier time, hasn't it, in the world of immigration?
Yeah, thanks, Emma. So, hi everyone, first of all, pleasure to meet you. Love to see such fantastic numbers on the call this morning. As Emma said, it's been a fairly frantic time in the world of immigration. really across all areas, covering sort of the immigration umbrella. So right the way through from changes to how multinational corporate organisations move their staff to the UK, right the way through to how things like the asylum system have changed, and the recent announcements around the Rwanda policy. Now, I could probably spend about 3 days talking about this sort of stuff, with the amount of changes that have happened over the last few months. I'm going to boil it down to 3 topics, really, which will have the biggest impact on you as employers. There are obviously an awful lot of changes around things like the asylum system and the way that the UK handles refugees, which are obviously incredibly important. From an employment perspective, then they're not quite as relevant as these 3 key topics I'm picking out today. So really what we're going to do, we're going to try and focus first of all on the introduction of the new global business mobility routes. Second of all, looking at some changes to the way that right to work checks are conducted. And then finally, just a quick look at where we are with Ukraine and what the Home Office and the government are doing to assist with relocation to the UK for any displaced persons as a result of the war. So if we start with the global business mobility routes. Now, this will only really have an impact on you if you are a multinational organisation and you are looking to move people around the world, obviously from overseas offices to the UK, or indeed you are working under international agreements. So, for example, if you have a contract in the UK as a result of a trade agreement or under an international organisation, then this will have some level of impact on you as well. So this came about the middle of last year, really. The Home Office asked the Migration Advisory Committee, so they are a body that informs the government on migration policy, to conduct a review of the old intra-company transfer routes, its effectiveness and any recommendations for change. And the Home Office, sorry, the MAC published their recommendations in the middle of last year and made a number of recommendations around making the routes more relevant to employers and to employees, importantly as well, and expanding it so that it covered a number of different areas as well. And the Home Office have adopted some of these. They've chosen not to adopt some of the recommendations, and the changes that they've adopted are really fleshed out in this new global business mobility route, or group of routes, effectively. And so as we can see on the slide there, it's broken down into 5 subcategories. You have senior and specialist worker, graduate trainees, secondment workers, service suppliers, and then UK expansion workers. Now, for those of you who are familiar with the intra-company transfer system as it used to exist before the 11th of April, the senior and specialist worker and the graduate trainee routes are effectively a complete like-for-like replacement of the existing ICT routes. So the graduate trainee, the rules are precisely the same. There is basically no change to the eligibility under that route. It's just the name has changed effectively. The senior and specialist worker routes, that is basically the same as the old ICT visa that you will have used, I imagine, for some of your more senior or specialist workers. And it's the main change is really the name, effectively. They've just made it a little bit more relevant to suit the types of roles that it covers. As you'll see at the bottom of the slide there, one small change they've made is that they've increased the minimum salary threshold for that category to 42,400. It was 41,500. It's just gone up ever so slightly for now, and that will be reviewed annually and is now benchmarked against certain economical data. So rather than it being a fairly arbitrary figure that the Home Office had established, it's now benchmarked to economic data based on the types of roles that are eligible under the route. So it's got a little bit more grounding in market rates and in labour economics. The skills threshold of the senior and specialist worker is still precisely the same. It's still that RQF level 6 type role, so basic graduate level type roles and above. You still have the same rules around needing to be employed overseas before you can transfer to the UK. You still have the same rules around needing to have been employed outside of the UK for at least 12 months before you move over. Obviously, that you don't need to meet that if the salary is above 73,900 at the moment, which is the higher threshold. And the length of visa that you can apply for has also remained precisely the same. Again, 5 years or 9 years if you meet that higher end threshold of 73,900. Quite interestingly, one of the things the Home Office didn't adopt from the MAC's recommendations was to make this route eligible for settlement in the UK. So one of the things that the MAC recommended when they reviewed the ICT category was to make the ICT routes eligible to, so any holders on it could apply for permanent residency once they'd completed 5 years in the UK. This used to be the case a long time ago, going back to when the points-based system was first introduced in 2008, and the Home Office stopped that a few years afterwards. And because of the introduction of the separate skilled worker routes, the MAC kind of viewed the ICT as becoming largely redundant if there wasn't a specific reason as to why someone would want to use it. So they said, look, let's make it eligible for permanent residency to keep it attractive and to keep it eligible for people to want to stay in the UK and have that flexibility around if their assignment becomes a permanent role in the UK, for example. The Home Office decided not to accept that recommendation. However, there still is the eligibility for anyone on this route to switch in country to the skilled worker route. So they will eventually get on a route to settlement. It will just mean that the clock won't start on their 5 years eligibility until they're in a position where they're actually on a skilled worker visa moving to the UK. Just one quick question I've seen come in. So the question is, under the new GBM routes, can employees apply for ILR, which they can currently do under the ICT route? So that's precisely what I just covered, actually. So they can't apply for ILR under this. They need to switch on to the skilled worker route and then switch once they've, or then apply for ILR once they've completed the 5 years under the skilled worker route. Quite interestingly, so something which is worth considering on this ILR subject is you obviously have the 5-year route under the skilled worker visa, but you also have a separate route to permanent residency where once you've completed 10 years lawful residency in the UK, you can apply for ILR, regardless of what immigration category you were under. So for example, if you had a high earner who had been in the UK for example, 9 years, the maximum granted leave available under the GBM route, and then they switched on to the skilled worker category, in 1 year's time, after they switched over to the skilled worker route, then they'll be eligible to apply for permanent residency on the basis of having completed 10 years lawful residency. So there are options available to you, depending on how long someone's been in the UK, but it's just worth considering how that factors in and how things change, because obviously assignments do change over time. And situations do change, so do consider that. Like I said, the graduate training route is effectively the same and is not used to a huge amount, so I'm not going to worry about going into too much detail on that. With the secondment worker, the service supplier, and the UK expansion routes. Now, these are routes which were to a certain degree catered for in other immigration categories, such as the representative of an overseas business route. What they've done, what the Home Office have done, they've tried to bring this under one umbrella to try and cater for anyone looking to move into the UK market. Now, the secondment worker is designed for an overseas company to send one of their employees to the UK to work on secondment at one of their customers for a period of time. There are very sort of specific restrictions around the value of the contracts and what type of work that person does, but that is basically what that category is designed to cover for. A service supplier is slightly linked to the international agreement routes, and anyone that's working under a trade agreement with the UK. There are a number of very specific criteria for how you can be eligible for a service supplier routes, and that's designed to try and make up for a bit of a gap in the immigration rules at the moment, whereby there's always a little grey area between what you can do in the UK as a visitor and what would require a work permit. And so the service supplier route is designed to basically bridge one of those gaps in the immigration rules, whereby there's that grey area between the visitor rules and what needs a work permit. So this is just designed to give a little bit more ease and a little bit more clarity around what needs a service supplier or what needs a visa when you're working in the UK as a service supplier under an international agreement or a trade agreement. And then finally, the UK expansion worker is designed to in large part replace the old representative of an overseas business routes. So if you are an overseas business and you don't currently have any presence in the UK and you're looking to expand in the UK, this is the category for you. You can send one of your employees to the UK to set up the business, essentially get everything trading, get a license in place, and then start hiring locally in the UK. So it's a very useful category if you're looking to move into the UK, and certainly one which is worth exploring if you are considering it. If we flick on to the next slide, then please, Emma. So, second subject we're going to cover today is right to work checks. Now, there's been quite a lot of change in the last month with regards to right to work checks, specifically around what you need to do online and what you can or indeed cannot do manually. Now, the Home Office have extended the COVID adjustment period for conducting right to works until the 30th of September this year. There's a bit of logic behind why they've gone for that date, and I'll explain this on the second slide as to why they've gone for there in particular. But effectively, it means that we're under sort of service as usual, effectively, as we've been for the last couple of years. So when you're onboarding a new member of staff, you don't need to meet with that person in person. You can conduct it over a video call like this. So, for example, if you're taking on a new member of staff and they're a British or Irish citizen, you get them to send you a scanned copy of their passport before the video call, and then you can set up a call just like this between yourself and the employee before they start work. Get them to hold their passport up next to their head so you can take a screenshot of them with their passport. Save that on your file, record it as a COVID adjusted right to work check, and then that covers you effectively. That gives you your statutory excuse against civil penalties if that individual is found to be working illegally in the UK. One quick question here from Adam. I can just see. So the question is, do we need to obtain written permission from new employees to carry out a right to work check with UKVI? Depends on what check that is that that is conducted. So the online check, well, sorry, I think the slides have just disappeared there for a sec. I'll carry on for a minute. So it depends on what type of check it is. If it's just doing a straightforward online right to work check. So for example, if someone has got a BRP card, or indeed they have status under the EU settlement scheme, then what will happen is that the employee will need to give you a share code, which is effectively their permission for allowing you to work for allowing you to conduct the right to work check. So that share code is what you will need to conduct the right to work check. If it's using the separate system, so for example, if you have a scenario where someone doesn't have evidence or the correct evidence of their right to work in the UK, and you need to use the Home Office's employer checking service, then in that situation, yes, you will need the individual's consent to contact the Home Office. You'll need some basic information from them anyway that you'll need to get from them, such as their date of birth and things, to be able to request it. But for the majority of them, the share code is effectively the permission. For the employer checking service, that covers the, like I said, you'll need to get permission from there. I think Emma's just rejoining us. Did you drop off for a second?
Yeah, no, I did. Sorry about that.
No worries. Okay, so we'll carry on with the right to work check. So since the 6th of April, employers can no longer accept BRP cards in person as evidence of right to work in the UK. You have a new member of staff that joins you and brings in their BRP card with them because they're an overseas national, then unfortunately you cannot consider that as being conducting a right to work check properly. You must use that online system that I just mentioned in response to Adam's question to conduct the right to work check. So I've listed there the categories that fall under this requirement. So if anyone holds status under any of these routes, so for example, they hold status under the settlement scheme, they have a BRP card in a particular user category, or there's other three that I've listed on there, then you must conduct the right to work check online. And as I mentioned just then, the way that it works is that the individual will log into their essentially their account with the Home Office, and they have a number of options as to proving their immigration status in the UK. And they will then generate what's called a share code, and they'll share that share code with you, and then you can plug that into the Home Office's system. So again, you quite simply you Google online right to work check. The Home Office sort of links will pop up. You input the share code, you input the employee's date of birth, and then it produces you with a very nice, very neat PDF document that you can save, and that is your statutory excuse against civil penalties. So it appears online, you download a copy of it, you save it onto the employee's personnel file, and that's it, effectively. So this is one of those things where the Home Office are mandating this because it's a lot more secure than conducting in-person checks. However, it's actually, practically speaking, an awful lot easier and an awful lot more secure and safe for you as an employer to conduct it online, because you're guaranteeing that the information that's recorded is correct. You're guaranteeing that, that you're recording all of the correct information for a particular individual and that it's formatted in the right way. And it's also a much higher level of sort of certainty that you're getting, because effectively you're accessing the Home Office's database rather than relying on a physical document that someone's giving to you. So it gives you a much more ability to conduct the right to work check. What I'm just going to do, I'm going to share my screen, because I'm conscious, I think Emma's having some, she's just back again. We'll just wait for Emma to share the screen again quickly before I continue. Just a couple of questions there from Joanna. So yes, I think we'll be sharing the slides after we finish. And the second question, can we continue the checks over a Zoom call with fully remote employees? So whilst the COVID adjustments are in place, Joanna, yes, you can do Zoom calls with fully remote employees. When the COVID adjustments end, you will need to follow whatever procedures are in place around that. Now, I'll explain what's coming in the next slide, which is probably going to help you. But in principle, you'll need to go back to manual checks for anyone who's based fully remotely once the COVID adjustments end. So if we just flick on to the next slide, please, Emma. So the big thing here, this is in reference, this is going to be a particular relation to yourself, Joanna, with fully remote employees. The Home Office are in the process of developing what they're calling a digital identity certification process, where they're effectively trying to design a system that will allow you to conduct digital right to work checks for everyone. So at the moment, the Home Office's online system only covers people who have a particular form of visa permission in the UK. So whether that be under the EU settlement scheme or they have a BRP card, it only covers that because that's effectively the only information that's in their database. And something that really came out and was debated at quite length in the House of Parliament was the fact that this system only actually really benefited overseas nationals. It did nothing to assist British or Irish nationals in the UK in terms of evidencing their right to work check. And so the Home Office have been trying to sort of work quite a lot over the last couple of years to try and put in place a system whereby you can conduct a digital right to work check for anyone, whether they are British, Irish, EU, the rest of the world, whoever. And this is what this system is designed to do. Now, going back to what I said previously around the extension of the COVID adjusted checks, my belief is that they've extended it until the 30th of September to coincide with the launch of this. Now, the Home Office haven't actually given any firm dates for launching the system. At the moment, they're very much through what I would call a beta phase in terms of the development of it. But I'd imagine that's where they're trying to benchmark it, so they have a realistic timescale to work to. Now, the way that it will work is that you as an employer will need to contact or engage the services of a digital identity service provider who will carry out the checks on your behalf. So this is very much a step away from the Home Office's current rules, which state that as the employer, you yourself must conduct the right to work check. So the way that the IDSP will work for you is that you will agree a contract with them, and depending on the size of your organisation will depend on what rates you're able to agree with the IDSP and how it works. But you will then effectively outsource the right to work check to that IDSP. So they will then go and conduct the check. So they will obtain the copies of the visa documentation from the individuals, passports, things like that, and then they will do a check, which is, and they are currently going through an accreditation process with the Home Office, whereby when they give you their results, that is a verified, assured check that based on the information that they've been provided, this person should have the right to work in the UK. And then that should be your statutory excuse against civil penalties. Now, these IDSPs, there currently aren't anyone who's actually been announced on the system yet, because they're all going through the verification process with the accreditors, but they will be announced in due course. And the Home Office haven't actually put any limitations on who can be an IDSP. They have set out the criteria, so there are a number of standards, of ISO standards that you must meet in order to be eligible, and making sure that you have various data protection procedures in place to make sure that the data is stored correctly. However, if you are a large employer, there is nothing stopping you from becoming an IDSP yourself and doing it all internally. So, for example, I know that a couple of the biggest supermarkets are looking at doing this themselves. So they are going to set themselves up as an IDSP and do the whole thing in-house, rather than needing to go and contract a third party and pay service charges and things like that to them. Now, obviously, I'm sure an awful lot of you currently do use service providers to do things like verify identity and do background checks, especially where there's a security nature to the role. A lot of those organisations will start offering this service once they're accredited to do so as well. So do discuss it. If you are currently using ID check service providers and things like that, do discuss it with them. Ask them if they are considering this, what their service offering is going to look like, because this will revolutionise how you conduct right-to-work checks going forward. It will mean that we can move away from a manual procedure for the vast majority of employees that you hire, and move to an entirely digital process, which will be more secure, more easy for you as an employer, and ultimately a lot quicker in terms of the onboarding process.
So is that going to be for every single employer? So no matter how big you are?
So there will still be an option to conduct manual right-to-work checks. So the Home Office are by no means mandating that you must do this. So obviously, again, it's horses for courses. If you are a small employer of 4 or 5 people, then it's probably not going to be cost beneficial for you, especially if you're all working in the same place. So, for example, if you're a coffee shop, it's going to be an awful lot easier just to do an in-person check on someone if they're a British or Irish citizen. When they come in on their first day, get them to bring their passport in the morning and do the right-to-work check as you've always been doing in the past. This is by no means a catch-all thing. However, if you're a bigger employer, if you have a more geographically diverse setup, so you have several offices around the country, you might not necessarily have a HR presence in all of your sites across the country, then this offers you a really good way to be able to conduct right-to-work checks securely without having to do them in person.
And will individuals then have to consent for their information to be searched by a digital?
I would imagine so, yeah. I'd imagine it'd be
thinking kind of with my GDPR hat on. There's some real kind of issues there about a third party. You know, what information is this independent? Well, I don't know, this sort of third party body going to know about individuals. You know, if you think about our own, because I'm always saying, you know, your identity and your information is your most precious of things.
Yeah, you're absolutely right, Emma, and this is why the Home Office have set up this accreditation scheme for it. So they're making sure that any people who, or any organisations that want to register as an IDSP, then they will meet all the relevant standards around data protection, GDPR, and handling personal data. And obviously as well, to a certain degree, this already exists when we do sort of employee searches and things as well. Yeah. So to a certain degree, and a lot of those organisations that do already do these sorts of checks, especially if you're doing things like security clearance and things, they already have their procedures in place to make sure that they're compliant with all the relevant data protection requirements as well.
So dig out your privacy notices, employers, because they will need some looking at and some updating, I would have thought. So just do bear that in mind as well.
So just a couple of quick questions coming up on the chat. On the chat. So Alison, I think we've covered yours. So will it be compulsory to use IDSP? No, absolutely not. It's optional, and it is entirely dependent on your structure as an organisation as to what works best for you. And their second question there from Sophie. So will this be a paid service with the IDSP, so an extra cost to companies? Yes, I imagine it will, because they are third parties. The Home Office are effectively outsourcing this to the private sector. So whichever companies are approved as IDSPs will probably charge you a fee. And again, I imagine that will depend on your size as an organisation. Volume, as in anything, will drive down cost. But again, because it's not mandatory, it's not something you have to do. So it's not like it's an absolute necessity for you to have to do this. It's an option for you, depending on where you attribute the risk, where you view the financial.
It's balancing that risk. We've also had another question in, Chris, about employees who don't have passports but do have birth certificates and national insurance numbers, and will they be covered by the digital checks?
Yeah, really good question, Alexandra. So it should do. I haven't seen the Home Office haven't published the details on how the IDSPs will conduct their checks yet. But based on the current right to work guidance, it should, because obviously if you're a British or Irish national, you don't necessarily have to give your passport. You can give a combination of other documents to evidence your right to work. And so in principle, they should conduct the checks in precisely the same manner that the right to work check guidance is worded. So in principle, I say yes to that.
Well, I think it's one really just to watch the space, and that is an awful lot of work to be done by the 30th of September when you think about what else is kind of going on in the Home Office. And that's a lot to be done.
And this is really worth saying. So I wouldn't be surprised if it's not in place by the 30th of September. Purely, like Emma said, because of the Home Office are under probably the most strain they've ever been under from a capacity perspective, whether it be because of just the existing pressure that was there anyway, or because of the Ukraine crisis. They're under a humongous amount of pressure. So I wouldn't be surprised if this is pushed back later than 30th of September. Brilliant. Okay, so if we click onto the next slide, please, Emma. We've got one more subject to cover quickly. So obviously, we need to cover the Ukraine conflict and what the Home Office and the government are trying to do to cover this. Now, this, as employers, this has some level of interest, because anyone that comes over to the UK under either of these routes is eligible to work in the UK. And this is very much a distinction between the existing asylum and refugee programs, where if someone comes to the UK and claims asylum, they cannot work in the UK until they are granted refugee status. Whereas with the Ukraine scheme, so with the Ukraine family scheme here, and then also under the Homes for Ukraine scheme, the individuals will have the full right to work in the UK from the moment that they touch down in the UK. So as employers, this is worth knowing whether you have someone apply for a job who's got status under this route, or indeed if you have connections with Ukraine, or if you have particular skill sets that you know need to be filled. It could be an area that you proactively recruit from as well. So you could try and make connections with local Ukraine community centres and say, look, we've got really good opportunities here where we can offer employment to anyone that's come over to the UK. Let's have a conversation. Equally, again, with the government, you could try and register with the government and say, and with your local authority, to say that we've got really good employment opportunities here. We're able to offer employment to anyone that's moved into the local area. Let's try and help with this. And so it is an important thing for employers to understand and appreciate, and something that's going to become quite important as the crisis develops and continues over the coming months. Now, there are essentially two schemes which cover Ukrainians trying to come to the UK. You have the Ukraine scheme, which is what we'll cover in this, and then separate the Homes for Ukraine scheme on the second, so which I'm sure a lot of you are aware of already. Now, with the Ukraine family scheme, this is for a Ukrainian national who has family members who are living in the UK. And I'll set out the eligibility there. I won't read through them at the moment, just because they're sort of quite detailed. Now, the Home Office really, and as I'm sure you've seen in the news, they came kicking and screaming to this. They were very slow to react, very slow to ease the rules, ease the application process. And it was really only because of pressure from journalists and from immigration lawyers and solicitors that they really came round to expanding the eligibility for this. Initially, it was only that they basically said, well, no, you're only eligible to apply if you meet existing family rules. So, i.e., you're either the partner or a child under 18 or a British citizen. They've now extended that quite drastically to cover extended family. So if you have parents who live in the UK, cousins, sisters, brothers. They've really expanded it quite drastically, and they've also, quite importantly, reduced the increased the evidential flexibility for when you apply for the visa. So the Home Office are willing to show an awful lot more flexibility around what types of documents you submit with the application. They're certainly not expecting anyone fleeing Ukraine to come with them with copies of their birth certificate, their brother's birth certificate, their brother's parents' birth certificates, and things like this. So they are showing a fair bit more flexibility in terms of how they're processing applications. In terms of how it's actually working operationally, initially there was a backlog because people still needed to register their biometric details at a physical visa application centre. Predominantly in Poland, because that was where the majority of applications were, and there are only 2 application centres in Poland, and so they were inundated, and there were quite a number of weeks where things weren't looking particularly good on the ground. And the Home Office has now relaxed this so that you can apply just on your phone, so it's just a digital status before you come across to the UK. It's really important that under the Ukraine Family Scheme, if you do have anyone who falls under this route, or indeed if you have any friends or family who are considering bringing someone over under this route, that they apply for the visa before they come to the UK. If they come to the UK without the visa, then they are at the behest of the discretion of the Border Force officials. If they're able to evidence their status to the Border Force official when they arrive, then they should be granted evidence, that they should be granted the appropriate leave at the border, and they can apply to switch once they come into the UK. However, that's very difficult because ultimately airlines and ferry service operators shouldn't be accepting anyone who doesn't have a visa to come to the UK in the first place. So it's really important that you go through the visa process, or at least get your documentation ready before you travel to the UK. It's really, really important now. And then finally, if we just quickly flick onto the last slide, please, Emma. So the Homes for Ukraine scheme. So this is where you can register your interest taking someone into your home. I'm sure plenty of you have registered your interest. This is at the moment is only designed for if you have someone who you already have a connection with, who you want to bring in. The Home Office, well, I say the Home Office, rather the Department for Local Government and Communities, is expanding this so that you can just register a blanket interest and accept anyone who meets the criteria to come across to the UK. At the moment, you need to know the individual to bring them into the UK. Not personally, you can't. All you need to know is know who they are. So if you, for example, if you've gone to a local Ukrainian community centre and said that you want to help, can you put some people in my direction, please? Then you can register through that way and go through that process. This is very much being developed and expanded. It's open for applications at the moment. But it's like with anything with the Ukraine crisis at the moment, it's very, very fluid. It changes basically on a week by week basis at the moment, depending on where pressure points are in the system. But it's there, it's open. You can register your interest with it, and I think people are starting to come across to the UK under the scheme as well. So yeah, and that's just about covers it from me as well.
I was talking to a client yesterday who has an operation in Ukraine, and what they've been able to do is where you've got that connection with, their UK employees knowing colleagues who work in Ukraine, so they're able to sort of utilize that as a way of showing that they've got that connection. So there are ways that you can, do that. But also, Chris has sort of flagged the work that you're doing to support and working within sort of a network of immigration experts to support people. So again, if people want to know more, then do get in touch with Chris because of the work that he's doing.
Thanks, Emma.
So lots going on. I think particularly in the immigration field, I think there's lots more opportunities there to be able to move people, particularly where you've got businesses abroad using the visa schemes that are available, and also being much more open to looking at candidates who are not based in the UK or Ireland. So some real opportunities there, I think, to sort of look beyond our shores at sort of recruiting the best talent for jobs that we have available. Thank you so much for joining us today. Apologies, I sort of dipped in and out there, but hopefully that's all been fine. If it hasn't worked, then Chris and I will just re-record and we'll send out the link to you, so don't worry about that. But thank you so much for joining us today. As I said, if anybody's got any questions or queries, then please do get in touch. But I really look forward to hopefully seeing some of you on the HR Masterclass in June, but if not, seeing you on our next webinar next month. Have a fantastic day and speak to you soon. Thanks again. Bye-bye.
Bye, Rob.